morning, everybody. Okay, so I seen this yesterday, but I just didn't have time to go over it and make this video yesterday, so we're going to get into this today. I noticed that on the 23rd, which was Tuesday, there was more documents that were filed in the Letecia Stauch case. So we're going to go over those documents, and it has to do with the mental health evaluation that she's asked for, okay? So we're going to go over these documents. Okay, so this first document, it was filed, it says up here, on June 12th, okay? But it was only put in the record, well, it was only put online on Tuesday, okay? So this is the people's motion to require the defense to disclose the mental health documents to the prosecution, okay? So I guess she's trying to suppress her records for this mental health evaluation. Okay, so it says the District Attorney of the 4th Judicial District of the State of Colorado, through his duly appointed Deputy District Attorney, respectively, move this court to require the defense to provide the following documents and information to the people. A. Any reports of competency evaluations, including second evaluations. Information and documents relating to the competency evaluation that are created by, obtained by, reviewed by, or relied on by an evaluator performing a court-ordered evaluation. The names, addresses, reports, and statements of each physician or psychologist who has examined or treated the defendant for competency. The names, address, reports, and statements of each mental health professional who has examined or treated the defendant for a mental disability or developmental disability. I can't speak this morning. Okay, the purpose of the competency status is to not penalize or punish the defendant. Okay, so they go on to state, it's rather the purpose of commitment for a competency evaluation is to furnish both the state and the defendant with an opportunity to assess the defendant's mental status, to determine if treatment is appropriate, and to ensure the protection of members of society. Okay, then it goes on to say CRS 16.8.5-104 subsection 1 states, when a defendant raises the issue of competency to proceed, or when the court determines that the defendant is competent to proceed and orders that the defendant undergo restoration treatment, any claim by the defendant to confidentiality or privilege is deemed waived, and the district attorney, the defense attorney, and the court are granted access without written consent of the defendant or further order of the court to reports of competency evaluations, including second evaluations, information documents relating to the competency evaluation that are created by, obtained by, reviewed by, or relied on by an evaluator performing a court-ordered evaluation, and the evaluation for the purpose of discussing the competency evaluation. Okay, it just goes on to say CRS 16.85104 subsection 4 allows the court to order additional information to be provided to the evaluator or either party in the case. Okay, and these are all just sections of the law. Okay, so 16.84104 requires the court to order both the prosecutor and the defendant or the defendant's counsel to exchange the names, addresses, reports, and statements of each physician, psychologist, or psychologist who has examined or treated the defendant for competency. 16.8.5105 allows the evaluator to use the medical and social history of the defendant to aid in performing an opinion as to the defendant's competency. The definition of incompetence, CRS 16.85101 subsection 12, requires in part that a defendant have a mental disability or developmental disability. Mental disability, in turn, is defined under CRS 1685101, subsection 15, as a substantial disorder of thought, mood, perception, or cognitive ability that results in marked functional disability, significantly interfering with adaptive behavior. Okay, and then it goes on. Each competency evaluation report must contain an opinion as to whether the defendant suffers from a mental disability or developmental disability under 16.8.5105D. In addition, it must include a diagnosis and prognosis of the defendant's mental disability or developmental disability. A complete mental health history is critical to reaching the correct diagnoses and determining the individual's prognosis. The people believe that mental health records exist but do not know where or what doctors treated the defendant, so the people do not have any meaningful method of obtaining those records on their own. Defense counsel, on the other hand, can talk to the defendant and or family members and can obtain information as to whether those records exist and where they are. Although defense counsel may not currently have this information in their possession, they can easily obtain it. A complete mental health history is essential for a thorough competency evaluation. Physicians and psychologists at the Colorado Mental Health Institute at Pueblo refer to have a complete history when evaluating a defendant. Similarly, complete mental health records are necessary to prepare for a competency hearing. The issue of whether mental health records must be provided to the prosecution in the context of competency has not been addressed directly by Colorado courts. However, that issue has been addressed in the context of insanity and impaired mental condition, where the Colorado Supreme Court has interpreted similarly worded statuses. In Gray v. District Court, just gives the code numbers in 94, overruled on other grounds, and People v. Ullery in 1999, the Supreme Court ruled that a plain reading of the sanity statute indicated that the legislature had created a statutory waiver to any claim of confidentiality or privilege to physician-psychologist-patient communications and medical records that predated and postdated the criminal offense, and that a defendant who asserts defenses of insanity or impaired mental condition consents to disclosure of information concerning the defendant's medical condition. The holdings in Gray were subsequently cited by the Colorado Court of Appeals in evaluating the waiver of privilege in the competency context, and they're referring there to People v. Zapata. Okay. The sanitary sanity statute, CRS 168-103, at that time also required the court to order both the prosecutor and the defendant to exchange the names, addresses, reports, and statements of any physician or psychologist who has examined or treated the defendant for his medical condition. The same language is now found in CRS 168-103.6. The current competency status provides a mechanism that could ultimately lead to dismissal of all charges. Oh shit. If the defendant were to be found by this court to be incompetent to proceed and restoration attempts ultimately failed, this court, after finding that there is no substantial possibility that the defendant will be restored to competency in the foreseeable future, could dismiss all charges. Oh shit. Sorry for the language, guys, but that's scary. Wow. Without impugning the motivations of the current defense counsel, it should be noted that competency proceedings have the potential to be used as a sword rather than a shield. It is possible that an individual, even in the defendant's situation, could ultimately have a full dismissal of charges through a finding of incompetence. Oh my lord. It is critical for a competency evaluator to receive as much information as possible in order to accurately diagnose the defendant and give an opinion as to competency. Oh, we see what she's trying to do now. Letecia. The defendant is not required to provide any documentation to the evaluator and could potentially refuse to cooperate, thereby creating a void of information. Oh, crap. Here the statute is clear that once defendant placed her competency at issue, she waived her privilege and the district attorney is granted access to certain mental health records of the defendant. To rule otherwise would provide the defendant and the defense counsel with the sole ability to provide or not provide information to the evaluator and strategically use that power to present select historical information that best suits their objectives. The people request that the court order the defense to provide the information and documents requested on this motion for the grounds stated above within 1 week of this court's order. Oh crap, guys. So this is why she's pulling this now. We all thought she wanted to get to the mental hospital because she thought it would be easier to escape. But no. This is why she's trying to do this. Okay? Because if she's found incompetent, they could dismiss all the charges against her. This psycho bitch is going to, sorry for the language, but this psycho bitch is going to try and pull this off where all charges are dismissed. Oh my Lord. Okay, so let's go to the next one. Okay, so this one is filed a motion to find a waiver of confidentiality or privilege for the defendant's medical and social history records pursuant to CRS 16.8.5104.1 and 16.8.5105. Okay, so this, the District Attorney of the 4th Judicial District and the State of Colorado, through his duly appointed Deputy District Attorney, respectfully requests this court find that the defendant, by raising the issue of competency, has waived any claim of confidentiality or privilege as to all information and documents pertaining to her medical and social history, and that the court order the release of such records to the people by the custodians of such records as grounds. Therefore, the people state as follows. Okay, and they're going over, I'm not going to keep repeating these numbers, but this is what they're referring to. Okay, so I'm going to say either 105 or 104. Okay, so 104 states that when a defendant raises the issue of competency to proceed, or when the court determines that the defendant is incompetent to proceed, and orders that the defendant undergo restoration treatment of any claim by the defendant to confidentiality or privilege is deemed waived, and the district attorney, the defense attorney, and the court are granted access without written consent of the defendant or further order of the court. Reports of competency evaluations, including second evaluations, information and documents relating to the competency evaluation that are created by, obtained, reviewed, or relied upon by an evaluator performing a court-ordered evaluation, and the evaluator for the purpose of discussing the competency evaluation. Okay, also, and this one's 105, allows that the competency evaluator to use confessions and admissions of the defendant and any other evidence of the circumstances surrounding the commission of the offense, as well as the medical and social history of the defendant in questioning the defendant. Emphasis added. Thus, by raising the issue of competency via its written motion on June 4, 2020, and verbally on the record on June 5th, the defense has waived any claim of confidentiality or privilege as cited above in CRS 104 to material pertaining to the medical and social history of the defendant. While the people do not believe any further order of court is strictly necessary as per CRS 104, it is nevertheless critical for us to obtain a written court order to facilitate our ability to subpoena the appropriate records from records custodians who are often out of state and who often request a written court order pertaining to a waiver. Any subpoena, duces, tectum issued by the people will have specific instructions to send or bring the records directly to the court and not directly to the people. This will provide an opportunity for the defendant to make any objections to the people reviewing these documents and may provide alternate options for providing these records to the competency evaluator. Therefore, the people respectively request this court find that the defendant has waived any claim of confidentiality or privilege to records concerning her medical and social history pursuant to CRS 16.8.5104 subsection 1 and 16.8.5105 subsection 3, and that the court orders the release of such records to the court by the custodians of such records for further consideration. Okay, people. Okay, so from what I gather from this is that's why Letecia has asked for this evaluation, okay? She's going to try and have all the charges dismissed. This is crazy. If this happens, there's going to be an outrage. This is crazy. Anyway, that is the records that have been filed on the 23rd, and this is just, this one down here is just the registers. Oh, I'm not even going to download that one. But this is just the register's actions, which, you know, between May 13th and June 23rd, everything that's been filed, which is what we just read. Sorry, people. Okay, so that's what's been filed. Obviously, the courts and the prosecution have been made aware by some means that she's going to try and pull this, okay? So they're on top of it, okay? So with that, we're going to end this, and once again, you guys, I ask that you subscribe to my channel. If you liked this coverage, please hit that like button and hit that notification bell so you guys are made aware when I upload new content. Okay? So until the next time, you guys take care of yourselves. Bye-bye.